Welcome to channel AMEC, your insight to the Australian visa system. G'day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrate to Australia? Why don't you consider to subscribe to my channel and turn on a little bell on the site. So once we have all the updates and news, you'll be the first one of getting all the insights. Now in this video, I'd like to take a common, not a very common question, but I've been repeatedly asked and inquired many times over my career practice as migration professions. It's about divorce. It's about separation of relationships. So what do you do and what to do? Now, anyhow, I'm not a specialist in the family law, but I do have some common knowledge about how it can be treated and how it should be treated, and of course a lot of time it's also related to the visa application as well. So in this video I'll discuss if there is a separation of relationship while you're a holder of a particular visa application, or perhaps you're looking to withdraw some of sponsorship and things like that. What should you do? Okay, let's jump into the actual content and detail of what you should do first. Now, obviously, under the family law of Australia, of course, that you at the moment you're actually seeing the web page is from Family Court of Australia. So the family law is legislated under the federal law, but the registration of relationships and the marriages are the state legislation. So it's a bit complicated. So I would like to take a little bit of a detail of what is required to be done. So obviously, to start with, I'm not here to promote the relationship should be ended. I'm actually promote harmony for whatever the relationship that you should have in your lifetime. But unfortunately, if things do happen, you should know what to do. Okay, so as you can see here, the law actually started back in 1975. That's where they had established. I'm not gonna go into detail because I'm not a family law specialist, but I'm showing you this is a website, a web page that's published by Family Court of Australia, and what you can do and what you should do. So let me move that a little bit over. Okay, can I apply for divorce? Okay, that's common questions. Now you can do it if you are obviously you're home in Australia, you're living in Australia, or you are a citizen of Australia or descent or by grant of citizenship. That's obviously mean you have an Australian passport. I think that's an easier way to describe it. Or you have ordinarily lived in Australia for 12 months immediately before filing for the divorce. So you can be a student visa. You've been there for 3-4 years. You can be employer sponsored working visa. You've been living there for 3-4 years. As long as you have been living in Australia for more than 12 months, you can then file a divorce application. Now, obviously, you need to seek your legal advice for a family law specialist what to do, but I'm gonna show you where you can go and more information that what you can actually get, and the costs. It's on the pages. Obviously, I'm not here to find any of these applications for you, but you can actually find it out by yourself. There is a guideline for fee exemption if there is whatever it is that require. Now, can I oppose? This is interesting. Can I oppose the divorce application? You can. In Australia, I'm not too sure for any other countries. Obviously, you can file a divorce application by consent of the two parties. So anyway, two parties. But in Australia, you can file it solely by yourself, and then the other respondent will receive responding notification, and then you can actually oppose, or you can agree, or you basically not to do anything with it. So if you have been separated for more than 12 months, now that's the actual mandatory requirement if there's no consent. Even if there is a consent, you can only file a divorce. You can be separated, but you can only file a divorce application after a 12-month separations. So under Australian law, they're giving each other a cooling off period of 12 months. So within this 12 month of separation, relationship might be better. You got back together, so obviously you don't need to file divorce application. Okay, so that's the general rule of thumbs of divorce common knowledge in Australia. So here we go. If you have been separated more than 12 months, and there are few opportunity of oppose divorce application, you can only oppose divorce where there has not been 12 months of separation. So pretty sure that's what I have just said and explained, and the court does not have jurisdiction. So that means the other party does not meet these criterias. They are not Australian, they are not living here, and they are not even a descendant or holding a Australian citizenship or passports. So that's the thing that you can do with. If not these things, then obviously you can't, because basically the other party had proved that the separation has been over 12 months. Okay, so if you do not want divorce granted, you must respond to divorce, and blah blah blah. That's all you're required to do. Now, obviously, once this is all done, it get into a very complicated stage. Now, the next page that I'm going to show you is within this link, how to apply divorce. Now, obviously, again, I'm not here to teach anybody to actually or promote anybody to divorce, but if things do happen, this is what you need to do to protect yourself. I'm all here to provide information for transparency purpose and to protect everyone's interests. Okay, now how do I apply it? There is step by step what you need to do. So as you can see here, before you start, it can be a joint application. If both parties agrees to it, you can do it. That's quicker, easy done. You can do it for sole application. That's for one party, but obviously you need to prove make sure that the separation has been there for at least 12 months. Are you eligible to apply? Again, that goes back to the first question: can I apply? So basically, you need to be either living in Australia for at least 12 months, or you're an Australian citizen or living there indefinitely. I think that's both the same. Anyway, there is a lot of ticking boxes that you may want to go through here. It's not my job to actually consult on this side. Again, you need to get your legal advice, because there are a lot of connection into perhaps assets, money, properties. What can you do with the property? Because you can be in a employer sponsor visa and owning a house, because you've been working there for 4 or 5 years under 457 or 482 visa as a chef probably, and you bought a house. Now if the relationship ended, obviously, if that house was bought in joint name or perhaps sole name under yourself, the other party may be able to claim the asset of you. So see, it's very complicated in a way. That's why always, even the government's website promote you to seek individual legal advisors, professional legal advisors. So that's the nitty gritty that I wanted to show you, and I think it's actually very common things nowadays, although we don't want to see things like this happen. But over 20 years of my business life in Korea, out working out in the society, I do see these things happen. So while it connects to visa, now it's that's why I wanted to share with you, because I've seen so many clients where they didn't pay too much attention while filing a divorce application and ended up with a huge complexities while at the time that you're required to file a visa application, because you do get a lot of questions. You bear in mind, every visa application will ask about your relationship, background, things like that. So that might be probably will be the last piece of supporting evidence required to actually be granted of your visa, and a lot of time it is that kind of case. That's why I wanted to do this video to actually notify everybody if things do happen, what you need to prepare. Now the next web page I want to show you is the I'm showing one of the state government's website. It's Queensland government, but I assume that most of other state government's website will be the same. So make sure, because during marriage or without marriage, any person is free to actually change their names. So if you do have any change names, for example, some culture, different culture have different aspects. When you marry, you change your name. You put your maiden name and whatever you require to do, and then you will have this change name certificate. Now make sure either that's in your party or it's not you, it's your ex-husband, ex-wife. You're required to have that evidence as well, because your divorce application or certificate might show the old name or might show the new name. And for as we are applying for visa things, it requires you to it's an ID. Visa is all about identification, ID, right? They need to verify all that. So all these kind of information are required to be recorded and provided at the time of decision making for your visa applications. Now, the last bit of web page I want to show you is within the immigration's web page. You can see that's Home Department Home Affairs. Now let me move that there. Now, if there is a change of your relationship during your time, nowadays all the visa application will have that condition. If there is a change of condition or circumstances of yourself, either it's change your address, change your employer, now even changing your relationship, make sure you report this to immigration. If not, you can be deemed to be mislead the government. So there are some few options that you can pick here. Now, obviously that relates to all type of visas. So one is the partner visa on the working visa, that's 457, 482, and 485. Prospective marriage temporary partner visa. Okay, so you haven't got your visa granted for your PR on partner visa purpose. I'm no longer with my former partner, spouse. I'm applying for student visa, begin new relationships, and I'm adding my partner into my temporary visa, or I'm a New Zealand citizen, family relationship, blah blah blah. So there's a different type. So let's go into, if I enter into a new relationship and then want to apply for a student visa, so what do I do there? So obviously you just apply for a visa. After applying visa, we want to have spouse and partner, then you need to add them in as a subsequent visa. Now you can always come back here, and if you ended your temporary partner visa, what happened? They require you to complete a form 1022, notification of a change of circumstances, and then there is an online form that you can actually do it through email account as well. So and here is another detail here. If there is a family violence situation, and if it happened that you are the visa holder, you might want to report this to the police and obviously notify your migration agent or lawyer. Through that way, there is a protection legislation behind it, regulation behind it, that you'll be able to protect yourself against family violence situation with the visa thingo. And there's also a part that where if partner dies, that's a change of relationship as well. Anyhow, this video is all about if there is a circumstances of change of your relationship between you and your partner, spouse, or de facto partner, what to do. Anyway, what is your thought? Do you think this is useful? And have you seen any other person around you having the same issue as well? Why don't you leave a comment right down below? Let us know what's this sort of situation and what did they solve, so we can help everybody out there with the transparency of information out there. Anyhow, that's for the video for today, and I see you next video. Goodbye.